wasn't even on. The computer wasn't even on, so good thing I went back. Is it 6 now?
Yep.
Okay, at 6 o'clock, I'll call the Tremont Planning Board meeting of Tuesday, August 27th to order. Roll call, we have Renee Hodgson, Brett Witham, Beth Gott, Ben Harper, myself, Mark Good, Planning Board Counsel, Patrick Lyons, sorry. Do you prefer Pat or Patrick? You don't care, do you? Okay.
I've been called worse.
Okay. Well, and our Code Enforcement Officer, John Larsons, who's joining us tonight. Katie was unable to make it. And members of the public. I don't see any reason to adjust the agenda. Minutes, they look fine to me. Anybody see anything?
I'll make a motion to approve the minutes as presented,
Say the date, please. July 9th.
July 9th, 2024.
Thank you.
I'll second.
Motion is second on the table to approve the minutes of July 9th, 2024. Any discussion? Hearing none, all in favor? All right, thank you. Okay, new business. We have a pre-application workshop for Locust Point, Maine, or Me LLC. Who's representing them? Hi.
My name's Jim Boyle. Where do I go?
You can sit right there,
Okay.
Jim.
All right.
I guess Tom is involved too, so.
I am. I'm just the bride and shop.
Okay, so this is just a pre-application workshop. First of all, you want to tell us about the project?
Sure. Yep. So
Is it Doyle or Boyle?
Boyle. with
Boyle,
me.
okay.
Yes, I'm Jim Boyle. I'm the project manager for Locust Point, Maine LLC. Roger Sangamon is also doing our soils and wetlands work. You already know following us. So, yeah, it's 27 acres on the end of Locust Point Lane, Locust Point Road, and Locust Point, Maine LLC purchased it on July 3rd this year. It's 11 lots. I believe you have the plans in front of you. We submitted them a couple weeks ago. So we're just here to sort of introduce ourselves, introduce the layout, use the sketch plan here, layout, and answer the questions.
Great. Any questions of Mr. Boyle, board? I see that Tom has the contour lines, 10-foot intervals, which is what we need, that or better. One issue that I saw was the access road here. You're calling it Locust Point Road. Locust Point Road, as you probably know, is a town road, and it ends right at the beginning of the subdivision there. And this is not a town road, so you need to rename that. Talk to our road commissioner, who's also our town manager today, and he agreed with that. So we do need a different name there.
Okay.
I saw, in our pre-application work procedure or submission requirements, it does say that you're supposed to have a portion of the USGS topographic map of the area, and I don't see where that's here. It's no big deal. Something we could deal with later.
It's in the upper left corner of the plan.
Is it right up here? It's the location map.
Oh, up there, okay,
But it's
okay.
USGS.
I guess, yeah. Is that on the small version?
Yeah, but
It
you
is.
can't read here, so you can't read it.
Oh, okay. No wonder I missed it. Okay, we got that. Thank you. Are the wetlands on here, Tom?
No, the wetlands are not on the map
Okay.
yet. They weren't done. They weren't done at the time of the submission.
Yeah,
This
okay.
materials.
Believe that. And I noticed in your application says that the parcel contains critical natural resources or wildlife habitats. What are they?
Can you address that?
Yep. Roger Sangamon. So there is some tidal waterfowl and wading bird habitat that is mapped along the shore That is below the highest annual tide line, so it's adjacent to the subdivision property, if you will, but I don't know that it affects any of the lots, because that starts sort of at the high water line and goes into the intertidals.
Yeah. I think one thing we'd be concerned with, that there's any approval from any relevant agencies regarding that. I don't know whether that's the case or not.
We've submitted a request for information to Maine Department of Inland Fisheries and Wildlife, Maine Natural Areas Program, so we'll provide those letters with the subdivision application package.
Okay. And you mentioned fire protection other.
Yeah, I didn't know exactly what to put for that, because I talked with Tom, and it seemed like that fire protection is, as long as we have a turnaround.
Just the local fire department, you're
Yeah,
saying?
we'll make sure that we have, I don't think the turnaround shows on here, but Tom and I discussed that afterwards, and we're gonna make sure that we have a turnaround, a hammerhead turnaround big enough for the fire equipment up toward the end of the road.
I show one right at the
T turnaround here?
Yeah, it's
Oh, hammerhead.
60 by 20 by 60. It's the
Yeah.
same layout as we did at Harkins. but
You're right,
it's
yeah.
Both sides of the road, they sent
I
it.
remember that, okay. And I see this RV site. Is that gonna continue?
That's just
It
an
just
existing-
crosses onto two
It's an
lots.
existing pad that has, electrical 30 amp service on it, but that's just because it's existing, I think that's.
I just
Sure,
labeled it
yeah.
as I saw it. I'll probably take it off the final plan. It's just a gravel pad, that's all it is.
Yeah, we're not gonna have RV sites there.
Right. Board members, anything? And you're probably aware that when you do the preliminary plan, that we're gonna need more information. I'm not gonna go into all detail because you can see it in the ordinance, but you need test pit analysis, I'm sure Roger's doing those. A deed, which isn't included here, stormwater management plan and things like that.
Stormwater, I guess that would depend, I can talk to Roger some more about that, but it would depend on the road width, what we end up with. So I guess we have to submit that information.
Yeah. If you look at our submission requirements for the preliminary plan, which would be the next step, it would require that.
Okay.
So do you have any other questions?
No,
think
like I
we're all-
said, getting familiar and introducing ourselves.
Yeah, I think we're all set on this. It's not really much to the pre-application workshop. We do need to schedule a site visit within 30 days of tonight. That would be the 26th of September. And we have a meeting on the 24th. That might be a good time. What do you think?
The 24th is fine.
Oh, it's September.
Stays light enough.
Right.
So,
So if the meeting is-
what would be a good time?
Time the cat has to eat.
And you folks, you're aware that we require that flagging has to be placed at the center line of any proposed streets, at the approximate intersections of street center lines and lot corners. Yeah, that's it then.
Yeah.
Okay. So you'd be able to do that before the 24th or by the 24th?
Check with my surveyor, he's saying yes.
Okay. Oh, and the other thing I want to mention, John mentioned this to Tom earlier about some of these measurements along the water line.
Yeah, I'll demonstrate that they're greater than 150.
Okay. For the preliminary plan.
Yes, yeah, the next meeting.
Okay. So I'll take a motion to schedule a site visit for the Locust Point Shores, you're calling it? subdivision on the 24th, and do you want to do it early, before the 6 o'clock? Does that work with everybody? Like 5 o'clock, or
5 works.
Yeah,
what's that?
5 works.
yeah.
Yeah, 5 o'clock.
See if Mr. Witham can do it.
September 24th?
24th. We only need 3 of us, so. But I know he likes to hike.
Like the bike?
Likes to bicycle.
What's that?
He likes to bicycle.
Bicycle. Well, he can bring his bike.
I think that looks good.
Looks good. 5 o'clock?
Sure.
Okay, take a motion to that effect.
Okay, go ahead.
I so move we do our site visit September 24th, 5 p.m.,
Locust Point Shores.
Locust Point Shores.
I'll second.
Motion is second on the table to schedule a site visit for September 24th, 5 p.m. for Locust Point Shores. Any discussion? Hearing none, all in favor? Okay, 5-0. Thank you.
Where are we gonna meet, right?
Oh, we'll meet there
Yeah.
at the end of the old Locust Point Road. Like,
I've never been beyond.
you've never been down to the end of the road there?
No?
Can we
Ag
all
Beach?
park down there?
Uh,
Well, the
I don't
road
know.
going in's quite long, so I think we could probably fit them in there.
what's that?
I said, there's quite a length of road there, so I'm
Yeah,
quite sure
yeah,
5
yeah.
cars you
Well,
can fit in there.
How far did I, I've never been past that point where the town road ends, so.
It's pretty long. There's a chain across that's locked, but we can, I'm assuming that I'm allowed to be at the sidewalk where you want.
Yes,
Oh,
yes,
absolutely.
yeah.
Well, I'll
Yeah,
make
you
sure
can
that
have-
the chain's open and we can drive, you can drive all the way into the shore, and there's a, loop down there, so there's room for 5 or 6 seats.
Okay, so that loop already exists, the road actually exists that far down there. Okay, yeah, because there's buildings, yeah.
Our road may move a little bit, but for the most part, no. Right on the
No,
same center line.
pretty much the center line.
Okay, yeah, so, yeah, we can drive right down. The flags probably won't be right in the center line, they'll be at the lock corners.
Yeah,
Yeah.
okay.
Make sure it's flagged up. There's room to turn around down there. And there's even an RV pad if you want to bring an RV.
Okay. In case you want to camp out, right?
Hopefully we won't have to spend the night, but
Yeah, yeah. Okay,
Okay.
thanks, you all set then?
Yes, thanks a lot.
Okay. Any other questions? Talk to this guy, our code enforcement officer, or our deputy code enforcement officer.
Okay, yeah, I've been emailing it.
Katie, yeah,
Very helpful.
yeah. Okay. Next, review of the remand from the business consumer docket to the planning board for findings of fact and analysis on access way for Pointy Head Campground and discussion to establish a meeting date and procedure. And so basically, as I'm sure you folks have all read this, we've got a remand from the court for the analysis and findings of fact regarding that access way. If you recall, we determined the access to the campground was through a driveway and therefore not permitted for that particular use according to our ordinance. So we're basically here tonight to determine the procedure of how to go from here and what we want to do. There's some questions here. Three of the board members were in on that decision. Brett, myself, and Beth. The other two are newer to the board, although Mr. Lyons has mentioned that they are allowed to participate. And maybe you can tell us why that is and what, if anything, they need to do to prepare.
Yeah, thank you, Chair Good.
I've met all of you, maybe not Ms. Hodgson. Patrick Lyons, I'm an attorney in law from Peabody, Ellsworth, where I live as well. So the remand, you've all read the order, as Chair Good said, and if you read the conclusion, it's looking for, hey, planning board, on this one issue, I need more findings. I need you to explain to me why it is that you found what you found. And then they say, hey, whether or not you want to commit new evidence is up to you. As far as having new members participate, it is a very narrow issue. It's whether or not the way you access this property is a road, a trail, or a driveway. And then tell me, of course, doesn't tell me why you made that decision. What are those findings and facts that it's based on? So it's a very narrow issue, and I think because you have, even though the new members may not be fully familiar with the entirety of the application, because it's a very narrow issue, I think it's something that they would be well within their ability to understand. Especially, what I would encourage the board to invite the parties involved with this, be it the applicant, folks that have been involved proposing the project, and also your code enforcement staff, to provide you with how they see it. Let them provide you argument as to whether or not this constitutes a road, or whether this is a road, a trail, or a driveway, and then what facts support that analysis.
Hold on a minute. I mean, basically what you're talking about is asking for more evidence. And
Not
I was going to get to that question
Not
next.
necessarily, no. So that's another separate question, is whether or not you want to accept new evidence, or that you believe that there's sufficient evidence in the record already to make that determination. So I think what I would suggest is that you invite argument from the various parties saying on this issue, let them, make that argument, and you can determine, ultimately what you believe to be correct as is your role here. The separate question of whether or not you permit new evidence, I think it's within your discretion, and ultimately I think it's whether or not there's any evidence that, if you determine there's sufficient evidence in the record already to make this determination, great. Again, I would let the parties make that argument, point to the record that's in the evidence, even give you copies of what was before this board. So again, the new members aren't having to sort through the entire thing. They can just say, what evidence was in the record that addresses whether or not this was a driveway, a trail, or a road? And let the parties say, here, this piece of information, this piece of information, this piece of information supports driveway, or supports road, or trail. Then the question is there information outside, is there evidence outside the record that is helpful in making this determination? And if you believe it is, then you would make a determination whether or not to admit it as new evidence, or you could say, we don't need this, there's already sufficient evidence in the record, we determine not to allow this evidence into the record. So I think that's well within the board's discretion, and that's exactly what the judge says. Determine whether it already has sufficient evidence in the record to make its finding or determination, or whether to take new evidence. So the only way you would know whether or not to do that, I would say, is by looking at what evidence is in the record and what new evidence may be proposed to you.
To me, we've heard arguments pro and con ad nauseum on this, and we have a substantial record of that. Whether that was presented to the court adequately or not, I'm not going to say. I have my own opinion. I don't think we need any new evidence, frankly. It's not a de novo proceeding here.
Well, in essence, it is, or it could be. And, you know, again, it's been remanded. The court said, hey, you didn't do this right. So now it wants you to do it right. And what right is under the law is you need to make specific findings based on the factual record of what supports your conclusion of whether that or not that the access way is a driveway, a trail, or road. So you're back to, you are the de novo body determining whether or not, you're the fact finder. So it is a de novo review of, but the question is are you just reviewing what's in the record, or are you going to entertain evidence that's outside the record that's relevant to this issue? What I would suggest is that you allow the parties, if they want to say, here's evidence in the record that supports this, and here's evidence, further evidence that we think supports this, and then you could determine whether or not you accept that evidence, and then make a decision either based on the record in the evidence or record in the evidence and evidence. Evidence in the record.
Board members, any thoughts on that?
I agree. I'd like to hear it. I think that I think there was not a ton of, there was a little bit of discussion about the whole road, trail, driveway, but I don't think there was a ton of focus on. I think assumptions were probably made. And now that this is the issue the court is really focused on, I want to hear the best arguments people have for why it's a trail. Could be kind of interesting if it's a trail, a driveway or road. And and so we can then just adopt, we don't have to, we can just adopt the best arguments and what we think makes sense as our findings of fact and conclusions of law. That's how I would do it.
Yeah, and just on that, I think in this instance, because it's been remanded, I would err on the side of including, the parties, including argument, and then documenting every decision you make, including whether or not you're going to allow new evidence. I think you should wait. You should allow the parties to submit, hey, this is the new evidence we'd like you to consider, and then you can determine whether or not you would like to bring it into the record. Whether you think it's necessary. If you think you already have evidence in the record that proves it not to be necessary, that's your decision.
I do know our code enforcement folks have been pulling all relevant files and preparing some findings for us to look at. Hopefully have that ready for us before our next meeting or whenever we're going to plan on considering this.
Yeah, and I think that's great. And obviously, the town staff that's familiar with this application and these materials would be in a great position to prepare that for the planning board. But also encourage you to invite that same proposal from the parties, and then, as the member with them said, we can a la carte, pick off the menu which one you think is the most you're most convinced by. Or you can kind of combine them. You can say, I like these proposals, but but from this proposal, but from this one, we should add that as well. Or you could say, we don't like any of them, we're going to come up with our own. But having those options allows, I think, the more argument that we can document, and then ultimately use that to come to your conclusion, is that's what the court's looking for. It wants your reasoning, it wants the evidence supporting that reasoning.
It just puts us in a place to have the best record for the next time around on that issue, which is basically what they said your record thinks.
Yeah.
You gotta do it again.
We just don't want it to be remanded again. My position is however you find it, whatever your ultimate decision, doesn't matter to me as long as you did what you're supposed to do to get there. Whether or not it's a driveway, road, or a trail, I'm just advising you on how to do this.
I don't expect we're gonna get 30-page briefs on this. I expect it's gonna be pretty, rifle approach. And, I don't know, and then we can talk about how the schedule and whether that be, everyone submits at the same time, or there's an opportunity to rebut, or how that works, but do you have a view on that? I'm curious,
I was just gonna ask
and we
about
invite-
written submissions. versus-
Yeah, written submissions, is there like a movement and then a respondent and a? or-
There's, I've seen it done a couple of ways. You can invite submissions and then provide for time and for a rebuttal submission, or you can just say, hey.
Based only on what's in the, because you want to give people, if there is new stuff that someone brings up, you'd want to give opportunity for someone to respond to that.
Yeah,
But-
you can give them the opportunity to respond to that in writing, or you can say, everyone submit everything a week in advance, and then at the hearing, at the meeting, where you can give those parties an opportunity to say, in response to this argument, I think that. Or if you want it to be in writing, you can do that. You can allow for kind of a rebuttal filing from the parties, and then you can say, hey, filings are due. I don't know, and again, it's what makes the most sense for this board to allow you the adequate amount of time to review the materials and be prepared for the hearing on this remand issue. You could say, hey, parties, you submit this information to us a week in advance. We want all your arguments and proposed evidence. And then 2 days, 3 days before the hearing, if you have any rebuttals, we want that. So we can have, and you could say, we're going to limit page. You have a lot of discretion.
Yeah.
And it's ultimately, the goal is what will be most helpful to this board, and to make sure we do everything the court wants us to do.
Usually we require submissions, our packets are usually ready on Thursdays before the meeting. And the day before that, so they can it can get into the packets.
Yes, you could say it's the Wednesday, if you meet on a Tuesday, you could say the prior Wednesday, everything's due, and then if you want to, advance rebuttal arguments, you can do that at the meeting. Whatever, again, I think what makes sense, and also how the town operates, if there's a process that works best for you.
Mr. Larson, 2 weeks before the meeting.
Gives us time to prepare. We're only here on Tuesdays and Thursdays.
Yeah, you guys, yeah. Wednesday afternoons.
Sometimes.
Sometimes, gotcha.
Again, it's I think coordinating with your staff, whatever, you guys think gives you enough time to have the staff get the materials to the planning board, gives you time to review the information, and then when you come to the meeting, then you can allow the parties to, I would then encourage you to allow all the parties a certain amount of time to, speak to you and talk, provide their arguments, provide any rebuttal arguments they have to the written materials. We can be very, structured about it and create a hearing format where the applicant gets, a certain amount of time, and then the board can ask them questions, and then you can even allow the other parties to ask them questions, and kind of do that down the line. It's really here, it sounds like you're gonna have the applicant, opponents of the project, and also your staff kind of also providing you information. So you can, rely on those three, allow others to ask questions, and then when you're listen to everyone, and they've had their, and again, you can limit it. You can say, hey, everyone's got 15 minutes, and so 45 minutes total of potential argument and presentation of evidence, and then you can close that and say, okay, now we're going to deliberate, no more argument, no more comments, and now we're just going to consider all this and make a determination.
So our next meeting would be September 10th. Then September 24th. And what's the first one in October there, Ben?
Would be the 8th.
The 8th? There's no deadline here that we have to meet.
No, I think, it's it's everyone's interest to do it as soon as you can, but at the same time, making sure to provide enough time for everyone to get those arguments out. So I would imagine, considering that your code staff is saying, give us at least 2 weeks before a meeting, it seems like maybe the first meeting in October makes sense, and then having submissions due 2 weeks before that, if that's what, what you guys are thinking about.
We're gonna have that subdivision application coming forward at the same time.
At the first October meeting. Okay. You prefer to go sooner? Attorney Pelleggi does have a trial that day on the 8th, and considering his involvement in this matter, I think it would be best to make sure he can appear here. So that's a consideration. I think if you want to move it up to the 24th, is that the day you're doing the site visit?
Yeah.
So then that would.
We don't want to do it on the 24th, make it after the 8th.
Oh, I didn't even see.
You say after the 8th is fine with you?
Yeah, so the following one.
What's the next meeting there? It's
22nd, October
22nd.
Dan, does that work? Yeah, that works. Okay. and then
How,
that's-
Brett, you're the one who's always,
Well, it looks like I'll be here.
okay, on the 22nd.
Yep.
Okay.
So then 2 weeks before that is the 8th, so submissions by the 8th, and then have the meeting on the 22nd. And I think considering that counsel for both the applicant and the opponents are here tonight, you may, I think one question is, if you do want any page limits or limits on time, we should, air them and see if we can get, an agreement here tonight that this avoids complications in the future. Would be my advice. It's up to you.
We don't know how to set page limits, but the briefer, the better. The
Yeah.
briefer, the brief, the better.
Yeah, I think considering it's a narrow issue, I would imagine that no one's going to want to go on too long about it.
Any thoughts, anybody else on that?
I like the briefer the better.
Briefer, the better,
Okay,
okay.
I think we can use that standard. As far as the hearing format, I would also encourage you to see if folks have a preference that you could entertain here tonight, so this would all be, on the same page and ready for it on the 22nd.
Well, I think if we're gonna do, I'll call it primary submission simultaneous and say limit to whatever, shorter the better. I was gonna say 10, no more than 10 pages. Then the next question becomes, on the rebuttal, I think we would limit the rebuttal to the substance of the you can't go outside what's been raised in the primary submission. Or we could say that. And I'd limit that to like no more than 5 or something. I try to keep the, we don't do, I don't know, double spacing, we're not like the core rules.
Yeah.
So I don't-
You've got these guys to
Figure that out.
figure that out.
And that's what I would do.
Well, if we're going to require a brief
Yeah.
by the 8th,
Yeah. I think
Just
they
2
could,
weeks
they could
before the
bring,
meeting.
bring copies of the rebuttal to the meeting, and then they can argue them, but we'll also have a copy. I'd like to have stuff in writing. So I want to go back and read it, and we want to.
I like it in writing too.
And I also don't want to cram people down. I know it takes 2 weeks, but I think the rebuttal could be basically the argument, and you bring it in writing. If there's anything you're gonna.
It's up to you guys, whatever you think is helpful. You could also say the rebuttal is due, a week before the meeting, and then you have a week to process it. Or you could
Does
say.
a week, does that work for you, or no?
Especially if they're 5 pages long, but if not, then yeah, you can bring it to, you can have them submit it any time, but then it's addressed at the meeting. It's really up to you.
Yes, sir.
Well, I'm not quite sure at what point did the planning board allow additional information.
I think we'll decide that. I mean, I don't know. I think we'll have to look at it, and I think we'll make a decision. If someone, in fact, what would probably happen is, if in a primary submission, someone brought something into the record that the other party felt was not part of the record. I suspect that that would be an argument they would make. This isn't part of the record. We don't think you should consider this. And then we'd have to decide, okay, can we take notice of this? Is it really new information? And just deal with it on an ongoing basis. But I doubt, I don't know that there'll be, like, I'm not aware that it was called, like, it had a road name at some point. That would be interesting to me, but I don't think it had. I don't think there's any new information out there, so I don't think it's gonna be an issue. But if it is, we'll deal with it on the fly.
Never had a word.
Yeah, I know.
Yeah.
So I don't think there's gonna be any new information.
Yeah, and again, to John's point, you know, whether or not you allow new information ultimately needs to be a determination made by this board, and you can't do that. I wouldn't advise you to make it tonight, because you don't know what
No.
you're proposing. But the court does specifically say that's one of the factors that should be determined, so I think, again, you know, you could also say the brief filed on the 8th needs to include any proposed evidence, whether it's already in the record or proposed new evidence, and then the parties can have the opportunity to review that, and then you have prepared and rebuttal arguments as to why, you know, that information should or should not be considered. And then the board at the meeting, you're gonna ultimately you're gonna make a determination whether or not this is a driveway or a road. But you're also gonna make some findings as to, whether or not you permitted new evidence, and then based on the evidence that is in the record as you determined, what is your conclusion as to whether it's a driveway or a road, is really kind of how I would do. And then the court picks that up. If this is appealed back to the court, they say, well, did these guys do what I asked them to do? And they can see that your process of, here's what, the parties were given, time to file briefs and evidence, and then they were provided an opportunity to rebuttal. And the planning board considered all this, provided them an opportunity to argue this in front of them, and then ultimately the planning board determined X on the issue of whether or not you permit evidence. And then based on the evidence that the planning board considered, their conclusion of law is Y. And then that's what, then you have satisfied what the court's saying you need to do, in my opinion. And again, inviting argument from the parties, and there's two very good lawyers on the other side, they're gonna give you, you can kind of, whatever one you find more persuasive, you can steal it and put that right into your decision. Or you can go with what the code enforcement officer proposes, or you might have a better idea and use that.
If the board chooses to allow new evidence, would we be required to hold a public hearing?
I would notice this as a hearing, and you can limit. Wouldn't be required to, but I would notice this as an opportunity for this. It's in essence what we're proposing is a hearing. You can as long as adequate process is provided, you can invite public comment too. You can say anyone from the public can comment on this issue, and we give them 3 minutes.
At a certain point, we're just like we're relitigating this whole thing, though.
We are relitigating it. The courts told us to relitigate it. That's really what we're doing.
On this particular issue, that's exactly what's happening.
I wouldn't advise you to go through these steps if I didn't think the court, if we're back here again, I didn't do my job. I mean, the less you do, there's more risk potentially.
So you're saying we should notice it as a hearing as well and allow public comment?
I mean, I don't see any reason not to.
You can limit public comment to the issue.
Yeah.
Before us.
To the issue.
Limited to 2 minutes of comment or something.
Yeah, so if anyone has, relevant information to provide on this issue, I would.
On whether it's a road, a trail, or a driveway.
So until we have the rebuttal or the briefs, we need a week to schedule the public hearing.
Well, I think the public hearing would be on October 22nd.
Okay.
So the meeting on the 22nd would be a public hearing, and we could provide notice and say the parties must submit we could say, the parties must submit their proposed, arguments and evidence by the 8th, any rebuttal argument by the 15th. And if you want to say 10 pages in the primary brief, or briefer the better, however you want to frame it, you could say no more than 5 pages on the rebuttal. And then you have the meeting, you run it as a hearing, you give everyone the opportunity to say their piece. You can limit the amount of time. You can say everyone has 15 minutes, 20 minutes to present their case in chief. Give everyone an opportunity to ask questions, and then you allow the public, if anyone in the public has anything relevant to say on the issue, allow them to speak, then you close the public hearing, and then you deliberate.
How's that sound, everybody?
Sounds like a plan.
Okay, so I'll need a motion regarding the briefs being due October 8th, rebuttals by October 15th. Let's do that first, and then we'll schedule the public hearing. Does that make sense? And do we want to set a limit on the length of the rebuttals? We already said, please make the briefs brief. Hopefully the attorneys understand that.
Did you just say that the rebuttals are now due the week before as opposed to at the hearing, is that what Mr. Wilson suggested?
Yeah, they'd be due the 15th, by the 15th. Does that make sense? No?
That's fine. And
The briefs would be due the 8th, and the rebuttal by the 15th.
And will the parties get copies of whatever the CEO is preparing at your request? Because I know we had
At some point, when that's ready, I would assume yes. Right, John?
Yeah, I think as soon as it's ready, John, you provide it to me, and I can distribute it to parties. Ideally, it would be on the 8th, but done by the 8th if possible, so that they can review it and provide any rebuttal to that as well.
Did you give it a crack?
Yeah, at the motion, yeah.
Thumbs up.
We'll do the briefs and the the rebuttal. Do we want to limit?
I'm gonna throw some stuff in there and see
Okay.
what people wanna do, and we can discuss it and revise it or whatever.
Okay.
So based on the remand from the Business and Consumer Court on the issue of whether the entrance to the Pointy Head project is a road, a driveway, or a trail, we will ask the parties to brief that matter. We will have a public hearing on October 22nd. We'll ask the parties.
6 p.m.
At 6 p.m. We'll ask the parties to submit, their primary written briefs or arguments limited to 10 pages on that narrow issue on October 8th, and simultaneously, and rebuttals at 5 pages, no longer than 5 pages, limited to the issues raised in the primary submissions. Those will be due on October 15th.
15th, yes.
In what format? They can file electronically, and we want to ask for a certain amount of written copies to be provided to the town for distribution.
How we usually do that.
Is that, yeah, how do you guys usually? What do you
I'm
do?
gonna stop right there, we'll add that. I'm gonna stop with that motion, and we'll tinker with stuff after. Is it, what?
I'll second it.
That's not what
Okay,
good.
okay,
Any discussion on that?
okay.
And then we can fine tune it,
We have a motion and second on the table. Excuse me, can't go through all that, I don't think. But basically, it was to schedule the public hearing for October 22nd, 6 p.m., right here, Harvey Kelly Meeting Room. Briefs would be due on October the 8th, and any rebuttals due by October 15th. Is that basically what you said?
Yes.
Okay.
And the briefs will be on the issue of the road, driveway, trail only.
Yes.
The parties may submit new evidence as part of that, and we'll consider it, as appropriate.
Okay, and the rebuttal's limited to 5 pages?
10 on the primary, 5 on the second one.
The primary.
Not one sided or both sides.
I'm not even gonna get into that. People. If it comes in like 8 font, double-sided, it's gonna be a problem. But
If we need a magnifying glass to read it, forget it. Okay, any discussion? You folks have that? Okay.
Yes.
Okay. John, okay.
We've got a second on that too.
Yeah, we had a second, yeah, that's any discussion. Hearing none, all in favor? Okay,
All right.
5-0.
Now, do we want to tinker with anything, like a form of, I don't know, how do we usually do it? Like, I don't know, I just do what we normally do, I don't know.
John?
Norm, I gotta put my microphone on.
Yeah. That's,
Normally, we get both
Submissions, yeah.
submissions.
And then we make.
electronically and,
We get electronic, and then we usually get the paper copy.
Paper?
Yeah.
Okay. So, is anyone okay submitting electronically and paper as well? Yeah.
Question, you just want one?
How many copies? One.
well,
One, I mean.
would you make copies for the board? Or do you think that the people making the submission should make copies for the board?
I'll make the copies, so, just like you normally get it.
Okay.
In the packet.
Okay,
Okay, when you do make the copies, then I think an electronic version is all you would need.
All we need.
You can just print it.
Yeah.
So they can submit, I would advise them to submit electronically on the due dates. And then John can print them and distribute.
So I'll make a motion that the written submissions are submitted electronically on the due dates.
Second.
And just, sorry,
Yeah.
a friendly suggestion, amendment would be submitted to both myself and the code enforcement officer, just so we all have copies that way.
Okay.
And then
Amendment.
it should copy.
I'll amend that motion to provide that the submit electronically to counsel for the planning board
Yeah, and I'd also make sure that they copy the other parties.
and copy the other parties.
Yeah.
And also to the code enforcement officer.
And that way everyone has it, and then John prepares it in writing for you, and he can send it to you electronically. We're off to the races.
Yeah.
Mr. Barrow, you're okay with that?
I am, I only one comment, but I'm okay with all of that.
Okay. Mr. Plaguey, you're okay with that?
Whatever the board wants is fine.
Don't say that.
Smoke signals.
Tell you what the board wants. Let me tell you what the board wants. Okay, we have motion, did we have a second?
Second.
Yeah.
Okay, motion second on the table regarding the submissions. Any discussion? All in favor? Okay, 5-0. Okay. Is there something we haven't covered, Mr. Lyons?
I know Lieutenant Barrow would like to comment.
Yeah.
I don't see anything.
Just that if the CEO is preparing, as you indicated, Mr. Chairman, his own findings of fact, that I would request that it be the CEO's work and that no board members be conversing with him while he does that out there talking.
And why is that?
Well, because that would suggest that if you're doing that, then you might be prejudging the issue if you were drafting findings of fact and conclusions before the hearing.
I think that's a good point raised by Attorney Barrow. At this point, I would consider, I would avoid any conversation with your code enforcement officer on anything substantive. In essence, I would consider yourself like a jury that's been sequestered, and you're not going to talk with each other or with anyone else about the merits of this. We now have a process set forward, and you guys are now basically the judges, and you just accept the written information that's been provided to you, and you make a determination based on that.
Wow.
Okay.
Okay.
Don't really do anything.
So moved.
Okay, nothing else. I guess we can set the date for our next meeting.
Well, does the CEO have any issues?
Any issues there, CEO? Say that in here.
I'll, I don't know what your process is for getting out notices for these subdivisions, but John, if you wanna, we can just figure out what that looks like and make sure it's, timely. I'll work with John to get the notice, the public notices out properly.
Do we want to limit well,
We can
do that at the meeting.
At the meeting, we can determine that at the meeting, yes. Do butters have to be notified?
I think in this instance, it wouldn't be in the excess of caution, I would advise that the butters be notified unless there's something, strong reason not to.
Okay, makes sense. Anything else? Otherwise, I'm gonna move on here. Set the date for the next meeting. You need a motion, September 10th, right here, 6 p.m.
I will make a motion that the next meeting be set for September 10th, 2024, at 6 o'clock here at the Harvey Kelly
Meeting room.
Meeting Room.
Second.
Motion second on the table to set the date for our next meeting, September 10th, 6 p.m. right here, Harvey Kelly Meeting Room. Any discussion? Hearing none, all in favor? 5-0. Okay, and what time do we have?
It is 6:52.
6:52. I'll take a motion to adjourn at 6:52.
I so move.
Second.
Motion second on the table to adjourn at 6:52 p.m. All in favor? Okay, thanks, folks.
Thank you.
Do you want this, or John want this, or?
Well, I don't know. You just left them here, and John should.
You want these?
You want these?
Oh, yeah, I gave.
Well, we're supposed to keep them.
Huh? Oh, yeah.
Well, I can print that.
I don't want to know anything about this project. Nothing.
That's the Lippman, used to be Walter Lippman.
Yeah, yeah.
And
lot of something.
Joe Kelly was his caretaker, and Joe's wife was the housekeeper.
Yeah.